The Supreme Court says the president used the wrong law to impose sweeping tariffs. A small importer celebrates for roughly the length of one refreshing browser tab. Then the next customs bill arrives with a 10% surcharge still attached. So what happened? Did the White House ignore the court? No, it changed doors, and the reason you are still paying is more revealing than any single tariff rate. On February 20th, 2026, the Supreme Court ruled 6-3 that the International Emergency Economic Powers Act, IEEP, does not authorize a president to impose tariffs. The majority's basic point was blunt. Congress knows how to delegate tariff power. When it does, it normally says duties, tariffs, or surcharges, and it supplies limits. IEEPA says the president may regulate importation during an emergency. The court would not treat that phrase as a hidden, unlimited taxing power. That was a real legal defeat. Roughly half of the nearly $300 billion in customs duties collected from January 2025 through the decision had come from the IEEPA tariffs, according to the Congressional Budget Office. But the court did not declare tariffs unconstitutional. It did not erase every tariff Trump had imposed. It said one statute did not contain this power. Hours later, the administration opened another statute, Section 122 of the Trade Act of 1974. This one actually says temporary import surcharge. It permits a broad duty of up to 15% when fundamental international payment problems require special action. It also comes with a clock, no more than 150 days unless Congress extends it. The new proclamation chose 10%. It took effect February 24th and, by its own terms, runs through 12:01 in the morning on July 24th. The old tariff wall lost a major section. A temporary bridge went up almost immediately. Washington does occasionally build quickly when the construction material is statutory ambiguity. In May, a divided court of international trade ruled that the Section 122 tariff exceeded the law. The fight turns on an unglamorous phrase, balance of payments deficit. The administration argues the country's international payment position fits the statute. The challengers argue that a trade deficit is not automatically the kind of payments crisis Congress had in mind, but a judgment and a refund are not always the same afternoon. In June, the Federal Appeals Court allowed the government to keep collecting the 10% surcharge while the appeal proceeds. So, as of this episode's July 14th research cutoff, the tariff is still being collected for most importers and is scheduled to expire 10 days later unless Congress extends it or events change first. The larger answer is that presidents do not have one tariff button. They have a toolbox Congress built over decades. IEEPA was the emergency door. The Supreme Court closed it for tariffs. Section 122 is the broad but temporary door. It has a 15% ceiling and a 150-day clock. Section 232 covers imports tied to national security. Steel, aluminium, autos, and other sectors can move through that door after an investigation. Section 301 addresses unfair or discriminatory foreign trade practices. It requires an investigation, findings, consultation, and procedure, but it can support duties targeted at countries, products, or practices. The U.S. Trade Representative said existing Section 232 and 301 measures covered about 30% of U.S. imports immediately after the Supreme Court ruling. It also launched or continued new Section 301 investigations. That is why killing one legal theory did not kill tariff policy. The toolbox was still open on the floor. Now the phrase that politicians keep trying to slide past the register, who pays? Customs and Border Protection requires the importer of record to deposit the duty when goods enter the United States. The foreign government does not walk up to the port with a check. A foreign seller may cut its price. The importer may accept a smaller margin. A retailer may raise prices. A manufacturer using imported parts may charge more, invest less, or search for another supplier. Usually the burden is shared, but the first legal payer is here. International Trade Commission found that American importers bore nearly the full cost of the 2018-era Section 232 and 301 tariffs at the border. It also found real gains for protected producers, less imported steel and aluminium, higher domestic prices, and higher U.S. production. Then came the second effect. Industries that use those materials faced higher costs, and their production fell on average. A tariff can help the factory making steel, while squeezing the factory shaping that steel into something else. Both factories get American flags. Only one gets the protected margin. The strongest defense is not that tariffs are free. They are not. The strongest defense is that paying a cost can buy something valuable. A country may want domestic capacity in steel, chips, medicines, shipbuilding, or other strategic goods even when imports are cheaper today. A tariff can give domestic producers room to invest. It can answer foreign subsidies or barriers. It can also create negotiating leverage, and it raises revenue while it remains in force. The administration argues that its tariff pressure produced trade agreements, encouraged reshoring, and confronted persistent imbalances. That case deserves more than a smirk. Markets do not price military resilience, supply chain fragility, or political coercion very gracefully. Sometimes the cheap supplier is cheap because another government wrote part of the invoice, but a strategic tool still needs a strategy. A broad tariff does not know the difference between a critical component and a harmless input. It protects some firms, taxes others, and invites retaliation against exporters. Frequent changes also turn business planning into weather forecasting with executive orders. Before the Supreme Court decision, CBO projected that the larger 2025 tariff regime would temporarily raise inflation, reduce real investment, lower real output, and reduce employment relative to what would otherwise occur. Removing the IEEPA tariffs reduced those projected effects. CBO also estimated that ending them would reduce tariff revenue enough to increase projected deficits by $2 trillion over 10 years, including interest costs, before accounting for uncertain refunds. That is the trade-off in one frame. Tariffs can raise revenue and support selected production, while also raising domestic costs and shrinking other activity. Anyone promising only the left side of that ledger is selling a policy without its receipt. The constitutional power to levy tariffs belongs to Congress, but Congress has repeatedly delegated pieces of that power to presidents. Those delegations were meant to provide speed, expertise, and leverage in foreign commerce. They also let legislators applaud protection at home and complain about prices somewhere else. Very efficient, institutionally at least. Courts do not decide whether tariffs are wise. They decide whether the executive used authority Congress actually granted and followed the limits Congress wrote. The Supreme Court checked the IEEPA shortcut. The Section 122 litigation is testing another boundary. Neither case answers the policy question for Congress. Should a broad, long-lived import tax exist? At what rate? For what goal? And with what exit condition? That question becomes concrete on July 24th. The Section 122 proclamation says the 10% surcharge ends then unless Congress extends it. Several outcomes are possible. Congress could vote to extend the surcharge. The tariff could expire while narrower Section 232 duties remain. The administration could build replacement tariffs through Section 301 investigations or other statutes, subject to each law's procedures and more litigation. Importers may also keep fighting over refunds for duties collected under authorities courts reject. What cannot be said honestly is that the Supreme Court ruling made the tariff issue disappear. It changed the legal map, cut the effective tariff rate, and forced the administration onto narrower roads. But narrower roads can still carry a great deal of traffic. Here is the judgment. The court was right to demand clear authority for a sweeping tax. The administration is also right that Congress has supplied other tariff tools. The weakness is not that those tools exist. The weakness is using a sequence of temporary or issue-specific delegations to approximate a broad, durable tax without Congress owning the full choice. If a nationwide tariff is essential to American economic strategy, its supporters should be able to win a vote, state the objective, name the cost, set a review date, and explain what success turns the tariff off. A policy serious enough to reshape every loading dock and checkout line is serious enough for Congress to put its name on it. So return to that customs bill. The Supreme Court did not erase the charge because the charge was no longer traveling through the law the court had just rejected. It moved from IEEPA to Section 122, while Sections 232 and 301 kept working in the background. The receipt is not proof that courts are powerless. It is proof that executive power often looks less like one giant switch than a ring of legally distinct keys. On July 24th, one key reaches the end of its clock. The next question is not whether another key exists. It does. The question is whether Congress will finally reach for its own.